Section 1. The Bankruptcy Shadow. What it is and why it lingers. Alright folks, let's talk straight. What is bankruptcy? It's a legal process when you're in a financial hole so deep you can't see the light of day. It's supposed to give you a fresh start. A court steps in, reviews your debts, and either wipes them away. Chapter 7. Or sets up a plan to get you back on your feet. Chapter 13. It can be a lifeline. Sometimes it is. But it doesn't just disappear. It leaves a big, ugly mark. For lenders, landlords, employers, that mark is a ghost. It follows you around. It whispers you had a major financial failure. A car loan becomes a struggle. A mortgage, too. You're seen as high risk. That's why removal, if possible, matters. It's not just about a number, it's about your life back. Proving your past doesn't define your future. Moving from desperation to control. No magic wands, no secret loopholes. Scammers promise the moon, take your money, and run. We stick to legal, ethical, honest steps. The FCRA gives you rights. Reports must be 100% accurate and verifiable. Section 2. Step 1. Arm yourself with information, your credit reports. Do it today, not tomorrow. All three, Experian, Equifax, TransUnion. You're entitled to a free copy from each every year. Go only to annualcreditreport.com. Don't be fooled by lookalikes selling add-ons. Print or save the PDFs. This is your battle plan. Read every line item, top to bottom. Find public records, the bankruptcy entry. Confirm case number, filing date, and whether it's Chapter 7 or 13. Review accounts included. This is your target. Circle it. Highlight it. Create a real and digital folder. Credit dispute. Every letter, email, and phone note goes in there. Step 2. The hunt for errors, scrutinizing details. Anything not 100% accurate is fair game. The law demands accuracy. You can dispute errors. Even small errors can be corrected or removed. If they can't verify it, it must go. Start with basics: name, addresses, social security number, birth date, then the bankruptcy details, filing date, case number, the correct chapter. Each discharged account should show $0 and note it was included or discharged. Balances owed, past due, or collections on discharged debts are serious errors. Check the timeline. Chapter 7 up to 10 years. Chapter 13 typically 7. If time's up and it's still there, that's illegal reporting. List every error, the bureau, the item, and what's wrong. Step 3. Launching the dispute. Fighting back with facts. Dispute with each bureau reporting the error, online, by phone, or by mail. Send certified mail with return receipt to build a paper trail. Keep undeniable proof of when you sent and they received. Be clear, simple, professional. No emotion. State facts only. Your full name, address, SSN, the exact item and account or public record ID. Example, case number incorrect, or an account shows balance but was discharged. Include copies, never originals, highlighting the correct info. Once received, they usually have 30 days to verify, fix, or remove, and they'll send results. Sometimes they say it's verified, even when it's wrong. Bring in heavy artillery, official court records. The court is the source of truth, not data providers. If they don't match, the court record wins every time. Get a certified discharge order and the docket sheet by clerk, mail, or pacer. If the court file has a typo, file a motion to correct clerical error. A judge's order is undeniable. Send a second dispute with certified documents and a direct statement of the correction. This often forces correction or deletion. You're escalating with proof they can't ignore. The long shot, goodwill and direct contact. If the entry is 100% accurate and within legal time, bureaus can report it. Goodwill letters may help trade lines, but rarely public records. Pay for delete is risky. Discharged debts shouldn't be paid, never for the main bankruptcy. Set very low expectations. Your strongest tool is proving inaccuracy. Credit repair companies write the same letters you can write. No secret back door. Watch for upfront fees and wild promises. If they tell you to lie, create fake IDs, or dispute everything, run. Reputable firms are cautious and honest. If you have undeniable proof and they still won't fix it, rare, but it happens. The FCRA lets you sue for false reporting and failure to correct. Hire a consumer rights attorney. Many work on contingency. Court is a last resort, not a shortcut to erase a valid bankruptcy. The real path forward, rebuilding your credit brick by brick, Bankruptcy knocked you to the foundation. Now rebuild with solid habits. Start with a secured credit card. Your deposit equals your limit. Use it for small planned buys, then pay in full monthly, no exceptions. After 6 to 12 on-time months, many upgrade and refund your deposit. Add a credit builder loan. Pay into savings, then receive funds at the end. These two tools build positive history month after month. Live on a budget and pay every bill on time. Payment history matters most. Keep credit utilization low, ideally under 30%. With consistency, scores rise and the old mark fades. Your action plan. 1. Get all 3 reports at annualcreditreport.com. 2. Check every line. Dates, numbers, balances, statuses. 3. Dispute errors with clear letters and proof. Send certified. 4. If needed, get certified court records and Escalate.